एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए.
A very warm welcome to everyone. We are back again with yet another informative video on this virtual Juridical series. Today, to speak on the very important subject, we have with us Advocate Shukr Usgaokar, who would be speaking on the topic of Motor Vehicle Act 1988. Specifically, he would be dealing on the directions given by the Supreme Court in Gohar, Mohammad versus Uttar Pradesh State Road Transport Corporation. Advocate Shukr Usgaokar graduated from V.M. Salgaonkar College of Law in the year 2021. He is currently working as an associate in the chambers of Senior Advocate Shri Usgaokar at Panjim. He practices in civil and criminal courts and tribunals in Goa as well as in the High Court of Bombay at Goa. I now request Advocate Shukr Usgaokar to take over this session.
Good evening everyone. I am Advocate Shukr Usgaokar, and in today's session I will be discussing the directions issued by the Supreme Court in the decision of Gohar Mohammad versus Uttar Pradesh State Road Transport Corporation. Last year in August, the Union Minister for Road Transport and Highways, Shri informed the Parliament that in India there are over 21 crore two-wheelers and over 7 crore four-wheelers and above registered vehicles in India. All these vehicles are governed by the Motor Vehicles Act of 1988. Unfortunately, the number of road accidents involving these vehicles is also on the rise. As per data provided by the ministry, in the year 2021, over 4 lakh road accidents were reported in India. Whenever an accident occurs, two types of proceedings are usually initiated. One is criminal proceedings, where the driver of the vehicle is prosecuted for rash and negligent driving and sentenced if found guilty. On the other hand, simultaneously, the victims of the accidents may also file civil proceedings for compensation due to the injuries suffered by them in the accident. In such proceedings, 4 people are usually involved. They are the owner of the vehicle, the driver of the vehicle, the victim, and the insurance company. It is in this latter category of cases that the Motor Vehicles Act plays an important role. Several major changes were made to the Motor Vehicles Act in 2019. However, it was found that these amending provisions were not being effectively implemented and enforced in the country. It is in this context that the decision of the Supreme Court in Gohar Mohammad versus Uttar Pradesh State Road Transport Corporation assumes significance. This decision has been reported in 2023 Volume 4 SCC page 381. I repeat, 2023 Volume 4 SCC page 381. It is an extremely important decision for the simple reason that until then many people were not aware about the rights of the victims and the procedure for claiming compensation under the amended Motor Vehicles Act. The facts of the case in a nutshell are as follows. One man was returning home from his factory to his home when he met with an accident, when his car collided with a bus, resulting in his death. The Motor Accidents Claims Tribunal, which is the court constituted under the Act to deal with cases involving payment of compensation to the victims, awarded a compensation of rupees 31,70,000 computed at 7% interest to the victim. This compensation was to be paid by the insurance company and eventually recovered from the owner of the bus which collided with the car. The owner of the bus appealed against the decision of the tribunal to the Allahabad High Court, which was dismissed. A further appeal to the Supreme Court was also dismissed, and the Supreme Court observed that the owner of the bus had been issued a permit by the State Transport Department, and this permit allowed him to use the bus only on a particular route. Since the bus was being driven on a different route, the Supreme Court held that there was a violation of the terms of the insurance policy, and hence it was the owner of the bus who was liable to pay the compensation money. During the arguments, it was pointed out to the Supreme Court that there was a huge delay in disposal of claim cases in India. It was also pointed out that there was a lack of general awareness about the changes which had been brought about by the 2019 amendment to the Motor Vehicles Act. Hence, the Supreme Court elaborately discussed the provisions which had been introduced by the 2019 amendment and issued directions for their effective enforcement and implementation. In this session, I will be briefly discussing a few aspects of this judgment. The first thing that the Supreme Court observed was that under Section 146 of the Motor Vehicles Act, it is absolutely mandatory to have a valid insurance policy while using a vehicle. A lot of people think that taking insurance is unnecessary, and in case of an accident, if and when it does occur, they pay from their own pocket. However, the law does not permit it. If you are using a vehicle, whether it's your own or somebody else's, it must be insured. Then, the Supreme Court also discussed the mechanism for claiming compensation in case of a motor accident. Whenever a motor accident does occur, the first thing that must be done is informing the police. The police officer who arrives at the spot will prepare what is called as the first accident report. It is very similar to an FIR or first information report which is prepared in case of criminal cases. In this first accident report, the police officer will note down all the important details regarding the accident, such as the date, time and place of the accident, the vehicles which were involved in the accident, the nature of injuries suffered, the details of the driver, owner of the vehicle and the victim, and so on. A copy of this first accident report must be given to the victim, and it must be sent to the claims tribunal within 48 hours. The victim must also be given what is called as Form 2, and through this Form 2 he will get to know all the documents, copies of which he is entitled to. He must also be given a flow chart which will simplify the procedure for claiming compensation. Apart from the first accident report, there are two other reports which are also very important. They are the interim accident report and the detailed accident report. In the interim accident report, what will be recorded is the version of the accident as provided by the passengers of the vehicle and the pedestrians who witnessed the accident. This interim accident report must be sent to the tribunal within 50 days of the accident. Then there is the detailed accident report. It is similar to what is called as the charge sheet in criminal cases. In this detailed accident report, all the relevant details of the accident will be recorded, such as the CCTV footage of the accident, the previous accident history of the offending driver, a scientific report proving the consumption of intoxicating substances by the driver during the accident, if any, the provisions of the Indian Penal Code and the Motor Vehicles Act under which the driver is to be charged, and so on. The detailed accident report must be sent to the tribunal within 90 days of the accident. Now let us come to the part which involves actually claiming the compensation. I will subdivide this into two segments. Firstly, uncontested cases, and secondly, contested or disputed cases. The law is that every insurance company must appoint a designated officer to process motor accident claims. Whenever the insurance company gets to know, either through the victim, the police, or in any other manner about the accident, within 30 days they must make an offer of settlement through the tribunal to the victim. The designated officer must also record his reasons why the amount which is being offered is just and reasonable. If this offer is acceptable to the victim, the tribunal will record the settlement, and within 30 days the amount must be paid to the victim. If the amount is not acceptable, then the victim must produce additional material and prove why he is entitled to a larger sum of compensation. The tribunal will hold a summary inquiry limited to the quantum of compensation and then award the compensation accordingly. Then there will be cases where the insurance company altogether denies its liability. Then in such cases, three options are available to the victim. Firstly, there are proceedings under 164 of the Motor Vehicles Act which are called no fault liability. Now what is this no fault liability? It means that if a victim files an application under 164, then it does not matter whether the driver of the vehicle was actually at fault or not. The victim did not prove any negligence on the part of the driver. So long as the accident occurred and it resulted in either the death of the victim or it caused grievous injury to the victim, then the owner of the vehicle is bound to pay compensation. In case of death of the victim, he must pay 5 lakh rupees to the heirs of the victim, and in case of grievous injury, he must pay 2.5 lakh rupees to the victim. However, once the amount is paid, the victim cannot claim any enhancement of the compensation. Once he accepts the compensation amount, the proceedings are closed. The second option available to the victim is to file an application under 166 of the Motor Vehicles Act. This application must be made within 6 months of the accident. In these proceedings, the victim must actually prove negligence on the part of the driver of the vehicle. However, if he succeeds in doing so, then there is no upper limit to the amount of compensation that can be claimed and that can be paid to him. Thus, the victim has two options. He can choose either one but not both. Both have their advantages and disadvantages. Under 164, he did not prove any negligence on the part of the driver. However, the amount of compensation which is paid to him is fixed. Under 166, he actually has to prove negligence on the part of the driver. However, if he does so, then there is no upper limit to the amount of compensation that he can receive. Lastly, there is one more option. Let us assume that the victim does not approach the tribunal at all, whether it is under 164 or under 166. Then the law allows the tribunal to treat the accident reports which are filed by the police as a claim petition and decide them accordingly. Thus, even if the victim does not knock the doors of the court, the law steps in and secures relief for the victim. Another aspect which was discussed by the Supreme Court is the jurisdiction of claim tribunals to entertain and adjudicate claim petitions. Let us assume that I am from Mumbai and I come to Goa. While in Goa, I meet with an accident. The vehicle which dashed against me was owned by a person from Belgaum. In such cases, the claim petition can be filed either in Maharashtra, where I, the victim, reside, or in Goa, where the accident occurred, or in Karnataka, where the opposite party resides. A question might arise, what if there are many victims? What if many claim petitions are filed? Let us assume that we, a bunch of tourists, from different parts of India are in Goa. They are traveling in a minibus which meets with an accident. Naturally, we the victims are from different parts of India and we would have filed claim petitions in different parts of India. Then the Supreme Court has held that in such cases, all of these claim petitions will be automatically transferred to the tribunal where the first claim petition was filed. These are some of the aspects which were discussed by the Supreme Court in the case of Gohar Mohammad versus Uttar Pradesh State Road Transport Corporation. As can be seen that unlike a criminal case where the victim plays a secondary role, like that of a spectator, while the main battle is between the prosecution and the accused, in a claim proceedings, the victim is central to the adjudicatory process. Thus, the decision in Gohar Mohammad's case will certainly be helpful in making victims aware about their rights and the role of the law in attempting to mitigate the loss caused to them by awarding monetary compensation. The decision in Gohar Mohammad's case will also go a long way in reducing the delays in disposal of claim petitions. A study conducted in 2010 by the Insurance Regulatory and Development Authority of India had revealed that there were over 3 crore claim petitions pending, and 85% of such petitions take over 5 years to be disposed of. Thus, the amendment to the Motor Vehicles Act in 2019, the salient features of which were discussed in Gohar Mohammad's case, is a step in the right direction to ensure speedy and effective justice for all. With this, I conclude my session by thanking the Member Secretary of the Goa State Legal Services Authority for giving me the opportunity to speak on this topic.
On behalf of the Goa State Legal Services Authority, I would like to thank Advocate Shukr Usgaokar for sharing this invaluable information on this very important topic of the Motor Vehicle Act 1988. Thank you, Doctor, for sharing the information. I also request all our viewers to like this video, share this video and subscribe to our channel. Thank you everyone. Thank you very much.
राष्ट्रीय न्यायिक सेवा प्राधिकरण
न्यायालयातल्या कारवाई खातीर बरो वकील मेळून दिता.
वेळार योग्य कायदा खालची मदत आणि सल्लो दिता.
लोक अदालत द्वारा चढ काळच्या केसीक बेगीन सोपयता
आणि ते बी सामके मोफत.
राष्ट्रीय न्यायिक सेवा प्राधिकरण बेस बरो न्याय बेस बरो समाज.
अधिक माहिती खातीर लागच्या न्यायालयातल्या न्यायिक सेवा प्राधिकरण कार्यालया लागीं संपर्क करा
वा टोल फ्री नंबर 151000 चेर फोन करा.